Your Honor, I challenge the jurisdiction of this court.
Okay, are you going to prepare any suggested voir dire questions?
Any what now?
All right. DJ Howard, I'm assuming you're Daryl Howard. Next, you have to name your device. Turn your video on. Mr. Malaro, will you as well? Hi, Mr. Howard.
I'm here, buddy. I'm here.
All right. This is in the matter of the people of the state of Michigan versus Daryl Lamont Howard Jr. File number 19-19661 H at Salvatore Malaro, appearing on behalf of Mr. Howard. I have Sarah Brenner appearing on behalf of the Attorney General.
No, I would like to represent myself.
Don't interrupt me, so hold on a minute. I have Sarah Brenner appearing on behalf of the people. This is the date and time set for a pretrial in this matter. This is actually a final pretrial before trial. We are scheduled for trial on March 9th, next week at 10:30 a.m. So, Mr. Howard, I will now, what did you say?
I said I would like to represent myself. I'm here in corporate persona. UCC 1-308, reserve all my rights.
Okay, so you wish to no longer have an attorney represent you?
I'm a man in flesh. I'm representing the subject. I'm here for the subject matter at hand.
That doesn't make sense.
I'm representing myself. I'm here. Okay, I'm here under God.
So you wish
to my man living.
Say it again.
A man living in flesh. Daryl Howard. For the record.
Well, you're not dead because you're talking to me. So, but I don't know what you're saying other than that. But so you no longer wish to have an attorney represent you?
Here in corporate persona, yes, Your Honor.
Okay.
No, Your Honor. I like to represent myself.
Okay, Mr. Malaro, Mr. Howard no longer wishes to be
represented.
Well, Judge, I would suggest that Mr. Howard hear out Ms. Brenner before he makes a final decision about having an attorney.
All right, so Mr. Howard, evidently something arose and Ms. Brenner has something she'd like to place on the record. So what I would suggest is that you hear what Ms. Brenner says and then perhaps you go into a breakout room with Mr. Malaro for him to explain the ramifications of it to you before you make, before I decide on your request to represent yourself, okay?
Yeah, I would like to, I reserve all my rights, UCC 1-308.
UCC does not apply to criminal matters, so
buckle up, guys. Today we are jumping into a courtroom where the defendant wastes no time turning a routine hearing into pure chaos. Before the judge can even finish introductions, he interrupts and starts speaking in strange legal phrases about being a man in the flesh and reserving his rights. The judge tries to keep a straight face, but it's already clear this hearing is headed in a very unusual direction.
Okay, so Mr. Howard, Ms. Brenner, do you have a statement you'd like to place on the record?
Yes, Your Honor. Mr. Malaro and I have been discussing this matter over the last couple of weeks and discussing potential resolutions. After discussing this with Mr. Malaro, even though when the defendant was originally arrested, he owed just over $5,000 and arrearages have grown to over $8,000 at this point, I have agreed with Mr. Malaro to offer the following. If the defendant wishes to enter a guilty plea today, then I would be asking the court to set a sentencing date out 60 days. If the defendant makes his payments during that time period, which is only $150 a month that he's ordered to pay at this point, I would be requesting no upfront jail at the time of sentence. However, if he refuses that offer and we proceed to trial next week, when I convict him, I will be asking for immediate remand and I will be seeking incarceration because of the level of increase in his arrearages. I feel that this is a very lenient and generous offer that Mr. Malaro has convinced me to convey today.
Well, for the record, at trial, there's a conviction, I always remand the custody of the Sheriff's Department. So if I ever have guilty convictions at trial, I take them into custody. So, Mr. Howard, so I'm going to go through that again with you. So the prosecutor and Mr. Malaro worked out a plea agreement that if you were to plead guilty, we would set sentencing out 60 days. And if in that 60-day period, you made the $150 per month payment towards your child support, they would agree that you would receive no jail up front at the time of sentencing. So at the time of sentencing, you would receive probation, but no upfront jail. So do you understand that's the plea agreement that has been reached?
Your Honor, I challenge the jurisdiction of this court.
Well, you have to file a motion, but you're set for trial next week. So
I've sent in 3 affidavits, ma'am.
affidavits for what?
For this particular matter, ma'am.
I've received no notice of any motions, Your Honor.
No, I've not received
I've sent
anything, nor have you served the prosecutor.
Now, the prosecutor lays all her cards on the table. She offers the defendant a surprisingly generous deal: plead guilty, make the required child support payments, and avoid immediate jail. But she also delivers a blunt warning. If he rejects the offer and loses at trial, she will ask for him to be taken straight into custody. Instead of focusing on the risk, he pivots back to challenging the court's authority.
When
Yes,
I
Your
had
Honor.
to hire an attorney to represent, when I had a civil case, I hired an attorney because there's a great philosophy that only a fool represents himself. You have the right to represent yourself. Do you have a law degree?
No, Your Honor, but if somebody,
Do you have
are
a
we
college
practicing law here?
education? Do you have
No.
a college education? Okay.
I had giggled.
You have what?
No, go ahead, Your Honor.
Okay. So, Mr. Howard, you feel free to represent yourself. Doesn't matter to me. But I'm just saying, you've been offered an opportunity for counsel who is intelligent and well-trained and well-experienced in the law. You may not like what he says, but Mr. Malaro always tells the truth. So, you do have the right to represent yourself. We received a letter. Okay, you sent a letter to the court, and you received a letter back stating that the court is in receipt of your letter mailed February 7th of 2022. Your letter is considered ex parte communication with Judge Anzalone, which is prohibited, Judge Anzalone, that's me, is prohibited from reading by Canon 3 of the Michigan Judicial Conduct Code. Additionally, you are represented by counsel and any motions must be filed by your attorney, and your letter was returned to you. So the court cannot read letters from parties because that is ex parte communication. So that letter was returned to you. If you file a motion, you must serve the prosecutor as well as the court. And so we don't have any motions, we just have a letter that you wrote. So you are scheduled for jury trial next week at 10:30 in the morning. Are you prepared to go to trial?
I'll speak with Mr. Malaro after this, Your Honor.
I'm
You want to
sorry?
speak to Mr. He wants to speak to Mr. Malaro? Is that what you said, Mr.
Yeah.
Howard? You want to talk to Mr. Malaro? All right,
Yeah.
I'm going to assign Mr. Malaro.
At this point, the judge gives the kind of advice every defendant should take seriously. She asks whether he has a law degree or even a college education, and when he admits he has neither, she reminds him that only a fool represents himself. She also explains that his letters to the court were never valid motions. The reality of representing himself is finally starting to sink in.
Mr. Malaro, are you ready for me to bring Mr. Howard back?
Yes, Your Honor.
That was pretty quick, Sam.
All right, Mr. Howard, you would ask for a breakout room with Mr. Malaro. Mr. Malaro and Mr. Howard, how do you wish to proceed today?
Your Honor, after explaining the offer to Mr. Howard, I believe he understands it. He's indicated to me he is not going to plead guilty to a felony of any kind, and he desires to represent himself in this matter.
All right. So, Mr. Howard, you wish me to remove Mr. Malaro as counsel for you, and you wish him to be a standby counsel in case you have any questions?
No, Your Honor, thank you.
Okay, so do you understand how to prepare jury questions?
I'm not
Yes,
sure I understand all the way, but I'm going to get it done. Your Honor, so what is
No, I'm
the...
talking now, Mr. Howard. So do you understand how to prepare jury questions and submit to the court?
I'm here purpose of signing, and I'll do it. I'll do what I have to do because under at least the laws of the land,
That's
I'm
not what
man.
I asked. So are you going to prepare any requested jury questions?
Am I going to prepare? Yes. Sorry. Excuse me.
Okay, are you going to prepare any suggested voir dire questions?
Any what now? Oh, I'm sorry. I didn't hear you. Yes.
Okay, you know, those were already those were due yesterday. So, I did not have voir dire questions. So, Mr.
Okay.
Howard, I received the voir dire questions from the people, but not from you. So, Mr. Malaro, is it possible to forward to Mr. Howard the voir dire questions and post your instructions that you received from Ms. Brenner?
Yeah, I can send them out to him.
Okay,
I'll have our
So-
investigator deliver it to his house today.
thank you. Malaro will make sure that you receive the voir dire questions and proposed jury instructions that were filed by the people. The people also filed a motion in limine, and we've already held a hearing on that. Is that correct, Ms. Brenner?
Yes, Your Honor, and that was granted.
Yep, it was. So, Mr. Howard, you're set for trial on March 9th. Are you prepared to go to trial?
If I could get an extension, that'd be great. But if I have to go March 9th, then that would be the time I would need to go.
All right, because you are self-represented now, I will grant an extension. It's only set for 1 day. So Ms. Adams, could you bring the red book, please?
Sure. Your Honor, the only week I would not be available is the week of St. Patrick's Day. Other than that, I'm available.
Okay.
After a quick private discussion with his attorney, the moment of truth arrives. His lawyer confirms that he fully understands the plea deal and still refuses to accept it. Not only that, he wants to fire his attorney and proceed alone. When the judge asks basic questions about jury preparation, he struggles to keep up, showing just how risky this decision really is.
What is the subject matter jurisdiction of this court? The subject jurisdiction of this court?
Well, you have to file a written motion, Mr. Howard.
Yeah.
All right.
For the record. Okay. Who's the injured party in this matter, Your Honor?
Mr. Howard, what?
The injured party in this matter, Your Honor?
The what?
Who's the injured party in this matter?
The injured party, the victim in this matter?
Yes.
Okay, that would be the person probably that you're supposed to pay child support to. All right, so I'm looking, how about April 28th at 9 a.m.? Are you available that day, Ms. Brenner?
Yes, Your Honor.
So I'm going to set this for trial on April 28th at 9 a.m. And Mr. Howard, that is in person, scheduled for 1 day. I am going to set a motion deadline for April 13. Wait, yeah, you're good. No, yeah, you're good. Okay. Are you available April 13th, Ms. Brenner?
Yes, Your Honor.
All right, so this is a motion deadline. So Mr. Howard, all motions must be filed and heard by April 22nd, which means you have to file it in accordance with court rules, with notice to the prosecutor's office, as well as the court. I'm going to require, Mr. Howard, that your jury instructions are also due. Mr. Howard, this court does voir dire, but I do accept suggestions for questions to be asked and understand they must be in accordance with court rules. And if they are not submitted by that day, then you will not have the right to add any. Do you understand that? Yes?
I have it all written down. Yes. I have it all. I mean, I don't want to accept the agreement, but okay.
All right, so I'm going to mail out the scheduling order, Mr. Howard. Okay, so we will make sure the scheduling order is mailed to you at that address. All right, so I have motion deadline and motion in limine deadline filed and heard. You have to prepare a notice of hearing and a proof of service, and it must be served on Ms. Brenner as well as the court. Do you understand that?
Yes.
All right, and you, once again, I'm going to ask, you do not wish to have standby counsel for trial?
No, I'm a man. Stand within my skin. Thank you.
I don't know what you said, but okay.
Thank you, Your Honor.
In the final stretch, the judge grants him extra time to prepare, but he continues asking sovereign-style questions about jurisdiction and who the injured party is. The judge patiently answers, sets firm deadlines, and offers standby counsel one last time. He declines with another cryptic statement, ending the hearing exactly how it began, confident, defiant, and completely convinced he knows better. If you enjoyed this courtroom breakdown, make sure to like the video, subscribe to the channel, and we'll see you in the next video.